Okay, back again. Let's move into part 2 of the CISG and look at how contracts are formed in this regime. Remember, the convention doesn't attempt to address every single legal issue that can arise in relation to an international sales transaction. It leaves several areas to domestic law, for example, title to goods, validity of contract, personal injury claims. We've talked about a number of those things already. What I want to do in this section is talk about basically the key obligations, how contracts are formed. So when we start learning about contracts in a common law jurisdiction, we start talking about offer and acceptance. So let's start there. So Article 14 deals with offers. So ultimately a proposal will be sufficiently definite for the purpose of being an offer if it indicates that the goods if it indicates what the goods are expressly or implicitly fixes or makes provision for determining quantity and price. So we don't need the same level of certainty that you might expect under a common law or Australian common law contract rule. So an invoice can form the basis of a contract, for example. If price or provisions for determining price aren't specified, the parties are assumed to have agreed upon a price based on that generally charged at the time of the contract for such goods under competitive circumstances. So offers a very broad concept under the CISG. And it's important to think about this because there are some key differences when it comes to formation. In contract law, the concept of a unilateral offer refers to a promise that one party makes, so the offeror makes, that isn't immediately reciprocated by a promise from the other party. So there's no consideration. So that's in common law concept of a unilateral contract. That actually does not exist under the CISG. So we don't have this idea of a unilateral offer, and consideration is dealt with in a really different way. So in Australian contract law, a unilateral offer creates a binding contract where the offeree commences performance in reliance of the making of the offer. So the classic example that we talked about in contract law are things like reward cases, where someone offers a reward for the return of a lost dog, lost property, lost homework, or for information leading to the arrest of somebody or other result. So the offeror is bound to pay the reward once someone performs the condition, returns the lost property, gives up the criminal, subject, of course, to a whole heap of exceptions, which I won't go through here. Australian law recognises the completion of the requested act as acceptance of the offer, creating the contract. And the key elements for the formation of contracts in Australian law: offer, acceptance, intention to create legal relations, certainty in terms of the agreement, and consideration are really kind of all bound up in our understanding of this kind of strange exception, a unilateral contract. The CISG, on the other hand, governs international sale of goods and has a different approach to forming contracts. It focuses more on the intentions of the parties and the information that they exchange between them, rather than strictly adhering to this common law approach. Offer, acceptance, consideration are all discussed or addressed in some way, but dealt with in a very different way. You might want to have a look at 18.1, Article 18.1. It specifies that a statement made by or other conduct of an offeree indicating acceptance or assent to an offer will in fact be treated as acceptance. It doesn't explicitly address unilateral offers. I think I've mentioned that already. Instead, it adopts this kind of flexible approach to contract formation that looks at the overall context and the parties' conduct and their intentions, which it's prepared to, as you already know, look at subjectively. It doesn't require consideration, which I think is probably the first point I want to make here, and it doesn't require consideration for a contract to be valid, and that is probably the most significant departure. So, what else? Acceptance by performance. The Australian law clearly supports the idea in the context of a unilateral offer, but as you know, past consideration is not good consideration. So, the CISG, on the other hand, deals with this kind of problem by thinking about the conduct of the parties. If it indicates that an agreement has been reached, it doesn't explicitly delineate rules for these kind of offers. It doesn't expressly have rules for acceptance, for example, or refer to unilateral contracts, which when we think about it is kind of closer to this meeting of the minds concept, which is more modern Australian contract law. What else? There's quite a lot of flexibility in formation. It focuses on the intent and the practices that the parties have established. So it's a lot more accommodating. There isn't any specific requirement for example, for writing, and there's no particular formal requirements for reaching agreement. Intention and certainty. Clearly both systems require intention to create legal relationships and a certainty of terms to a level for the contract to be valid. But the CISG's provisions on these points are interpreted within the framework of international trade, considering the parties' statements and conduct in the context of the agreement and their relationship as a whole. What else? Another key difference is this the concept of revocation of offers. So the revocation of an offer is a critical issue when it comes to contract formation, and the rules tend to detail how and when an offer can be withdrawn before it's accepted, because once it's accepted under both regimes, we have a binding, valid and continuing contract. Both Australian contract law and the conventions have provisions dealing with the revocation of offers, or rules dealing with the revocation of offers, but the approach is quite different. So under Australian contract law, largely based on common law principles, as you know, an offer can generally be revoked at any time before it's accepted, provided that that revocation is communicated to the offeree. So that means that the person to whom an offer is made has to be aware of the revocation for it to be effective. So communication, timing, and of course there are exceptions, but the principles are pretty clear, and I assume you're very familiar with them. Under the CISG, on the other hand, the approach is a lot more structured and outlined in Articles 15 and 16. So Article 15 says that an offer becomes effective when the offeree receives it. It indicates that an offer can be withdrawn if the withdrawal reaches the offeree before or at the same time as it's been accepted. Article 16.1 allows for an offer to be revoked if the revocation reaches the offeree before they've dispatched an acceptance. However, the CISG imposes a more restrictive condition on revocations compared to the common law. Article 16.2 specifies that an offer cannot be revoked if it indicates, whether by stating a fixed time for acceptance or otherwise, that it is irrevocable, or if the offeree has reasonably relied on the offer as being irrevocable or has acted in some way in reliance on the offer. So here, the fact that there isn't an acceptance isn't enough. There needs to be some act, even if you haven't verbally communicated, something that's done in reliance of the offer being a good offer. So the similarities and differences are hopefully outlined on the slide. Communication and timing, irrevocable offers, flexibility in the revocation, and this question of reliance. So both allow for the revocation, it's just the conditions are different, and something that commercially people need to be aware of in the negotiation phase, because heaven forbid you end up in an agreement because of the activities that have been undertaken, even though matters are still being negotiated. What about acceptance? A contract comes into existence the moment the offer is accepted. That's Article 18. But acceptance can be by performance of an act. So if you say, ship me a dozen computers at your usual price by August the 5th, if the seller responds by actually sending them to you, you have an agreement under the CISG, which would be really difficult to prove under Australian common law principles. Counteroffers. Remember counteroffers? A counteroffer is actually a revocation of the original offer and the creation of a new offer under the common law. But actually, a counteroffer might actually be a form of acceptance under the CISG. The battle of the forms type cases are the ones that are most interesting here. So think about circumstances. What if the offeree accepts an offer but at the same time wants to change the price of the goods? Any material change is going to be a rejection of the offer. But if the change isn't material, it's just an amendment to the offer. Very different concept from what we are used to. Performance obligations. The CISG imposes general standards of performance on both the buyer and the seller. So take a look at Articles 53 and 54 in this regard. Basically, both parties are entitled to get what they expect from the contract. And if one party breaches the contract, the other party has the right to avoid the contract or to make a demand for specific performance. The remedies are quite different. In an Australian common law position, we need to work out, is this a warranty, a condition, or some kind of intermediate term? In a way, I find that easiest way to think of the regime under CISG is everything's an intermediate term. There is this concept of fundamental breach. So Article 25, again, a little similar to this idea of is this the assessment tools that we would use to work out if there was an intermediate term or not. A breach will be considered fundamental if it results in such detriment to the other party as substantially to deprive them of what they are entitled to expect under the contract, unless the party in breach did not foresee and a reasonable person of the same kind and the same circumstances would not have foreseen this result. So it's important to actually recognise that the key issue here is around foreseeability and detriment. And so these are the issues that are quite often the subject of disputes. Avoidance. It's just a fancy CSIG term for termination or cancellation. So Article 26 sets out when a contract can be terminated. And Article 82 is relevant here too as well, because it sets out the obligation that you can't just terminate and then keep everything. You have to return things if the buyer is terminating. Now, I've got some more slides on termination to come, so I'll talk about it in a bit more detail to follow. Another thing that's worth understanding is that there is a right under the CISG to specific performance. Take a look at Article 46, and I will talk about this in a significantly more in another video. In the next video, I'm going to start talking about the seller's specific obligations. I'm hoping these last ones will be quick and dirty. I just really want to give you a high level idea of what to look at and to point out some of the significant differences with what you're used to, so you can explore it at your leisure properly. Questions, concerns, frustrations, or compliments, send me an email, give me a call. Cheers.